Thank you, Christoph, for that wonderful introduction. I think you left one important thing out, namely that I wrote my master thesis with you. I think that's an important detail in my resume. So I wanted to start my paper by thanking, of course, the organizers of this workshop, but also the other two speakers, Rens and Alte, for their wonderful papers. I also learned a lot. And as Rens already mentioned, I really have to thank Alte for raising the subject of Roman law, because yes, we are always a bit on the sideline in the classics field. So I'm extremely happy I am here, or I am able to talk a bit about the law today. It does also mean, I think, that my presentation will be slightly more technical than the previous two ones. I'm also aware of the fact that I'm the only thing standing between you and usually the drinks, but now in this case, the breakout rooms. So I will try to stay within my time limit. Just to check, can everybody hear me clearly? Yes?
Yes.
Okay, wonderful. Well, let's get started then. Let me see. Yeah, great. So in the third section of his speech in defense of the poet Archias, I'm sorry, I pronounce it in a Dutch way, can't do anything about it. Cicero comments on the style and content of the speech he is about to deliver. And he says the following: "It may, however, be a matter of surprise for some of you that in a legal inquiry, in Quaestione legitima, and in a public trial, in iudicium publico, held before a specially selected praetor of the Roman people and a jury of the highest dignity, in the presence of a crowded audience of citizens, my speech should be made in a style out of keeping not merely with the conventions of the bar, but also with forensic language." So while apologizing for his somewhat unusual way of speaking, Cicero actually offers us a very brief insight into the court setting of the speech and the trial itself. So what is this public trial? And who is this praetor, especially selected by the Roman people? And who are these severissimi judices Cicero is addressing? Well, those are the questions I would like to talk about in my paper. And I decided to divide my paper in three parts. First, I would like to say, by way of introduction, a little bit about the legal aspects of Roman citizenship, because Roman citizenship takes such a prominent position in this speech. Subsequently, I will discuss the iudicium publicum. So I want to say a little bit more about the procedural context of the speech. And then finally, I will turn our attention to the Quaestio legitima, so the legal argumentation in the Pro Archia, and discuss how Cicero deals with these questions of citizenship or concerning Archias' citizenship. So let's then start with the first part. So as has become abundantly clear from all of the other presentations, Archias' case centers around the question whether the poet, who was originally from Antiochia, had obtained Roman citizenship at some point in his life. It might therefore be useful to first make some general comments on the legal aspects of Roman citizenship. So what do Romanists, so that's basically people who study Roman law, actually mean when they talk about Roman citizenship? So nowadays, citizenship is usually determined by the country you are born in or the country you are live in. This conception, which in essence connects citizenship with geographical location, is a relatively modern idea, and it was in a way unknown to the Romans. Not all inhabitants of the Roman Empire were Roman citizens, at least not until 212 CE. Whether you were a Roman citizen was usually determined by your lineage. In short, children born from a legal marriage between two Roman citizens obtained Roman citizenship. It did not matter where in the empire your parents lived or where you were born. If your parents were Roman citizens, you were one too. All other free persons were referred to as foreigners, peregrini. Their citizenship was usually determined by the community or their city of origin. In some situations, however, these peregrini, like Archias, could acquire Roman citizenship by means of a grant by the Roman authorities. During the Republic, the Roman people had the competence to award Roman citizenship to individuals or to entire communities by means of a statute, so a law or a lex in Latin. Examples of such laws are the Lex Julia de Civitate of 90 BCE and the Lex Plautia Papiria de Peregrinis of 89 BCE, which play a role in Archias's case. But first, you might wonder, okay, so why do you even want to acquire Roman citizenship? You have another type of Roman citizenship. What is so good about Roman citizenship? Well, it was mentioned in the previous papers, it's a thing of status, of course. But from a legal perspective, Roman citizenship also came with considerable legal rights and benefits. First and foremost, and one should not underestimate this, Roman private law only applied to Roman citizens. In legal literature, this phenomenon is referred to as the principle of personality, or the personality principle. The idea is that the law and the legal system of a certain state or community is only applied to its own citizens, which is, of course, very different from our perspective nowadays, where the law is applied to everybody who is in a certain country at a certain time. Becoming a Roman citizen, therefore, not only allowed someone to make use of, let's say, Roman material private law, for example, when they were concluding contracts, but also enabled him or her to make use of the well-developed Roman court system. Another advantage was that the Roman citizenship and the application of Roman law also came with a set of very convenient and often profitable testamentary rights. Not only Roman citizens could create a valid or a will valid at Roman law, and more importantly, only Roman citizens could be a beneficiary of such a will. Thirdly, Roman citizens also had connubium, so that is the right to enter into a legally valid marriage with another Roman citizen, and therefore ensure that if you have children, they would also be Roman citizens. Finally, and this is often overlooked, but I think it's actually a very interesting aspect of a Roman citizenship, the citizenship came with certain public and constitutional rights, such as, for example, the right to appeal against a death sentence, always convenient, and the right to vote in the popular assemblies or even stand for public office yourself. Well, with that in mind, let's then move on to the second part of my talk, namely the iudicium publicum. So we're now zooming in on the speech itself. So perhaps we should start with the legal basis for the prosecution. So why are we even talking about a trial? From Cicero's speech, it becomes clear that Archias was prosecuted on the basis of a criminal offense, and therefore the trial was a criminal trial. The exact legal basis for the claim against Archias is actually not mentioned by Cicero, but he does, however, refer to a certain lex papia in paragraph 10 of his speech, and I've included that on the slides. He says, what? Others have found some way of creeping into the roles of the cities I have mentioned, not merely after they had received the citizenship, but even after the passing of the law of Papius. Well, that is, of course, a rather vague reference. There were many leges papiae, but this very specific, or this specific phrase has prompted the author of the Scholia Bobiensa, which is a late antique commentary on the 12 speeches of Cicero, to infer that the prosecution of Archias must have been based on the so-called Lex Papia de Peregrinis of 65 BCE. And I have also included this particular part of the commentary on the slide. He says, therefore, Archias was prosecuted under the Lex Papia, which had been passed to punish those who falsely and illegally claimed Roman citizenship. Nowadays, most authors agree that this is the law, or that this law was indeed the legal basis for the case against Archias. However, its content is still very much disputed. Some scholars argue, in line with the Scholia Bobienza, that it only allowed for the prosecution of persons who falsely styled themselves as Roman citizens. So we were just pretending to be Roman citizens. Other scholars give it a wider scope, and they contend that it actually forbade all foreigners to be in Rome, perhaps under some kind of time restriction. So perhaps it was only issued for a certain period of time, or for that they were not allowed to be in Rome during certain events. We don't know. Either way, whether you go for the first interpretation or the second, I would say that the indictment against Archias would always have been the same. Archias was falsely claiming to be a Roman citizen, and this is expressed with the Latin words usurpatio civitatis, which I find a very, very beautiful expression, actually. So this is the basis for the prosecution. And then we should say, I maybe should say something about the court, because this is a very interesting part where Roman law very much is very different from modern, at least modern continental law, because the Romans did not have one criminal court in which all offenses were tried. Instead, they had courts for every separate criminal offense or group of criminal offenses. And these courts were referred to as the so-called quaestiones perpetuae, or another term used is iudicia publica. And this is, of course, the term we saw Cicero himself use in the exordium of his speech, which I cited at the beginning of the paper. Each of these courts was established by an individual statute pertaining to this specific criminal offense. And in this case, the criminal offense was, as I mentioned, usurpatio civitatis, so falsely claiming Roman citizenship. It is not completely clear when and by which statute this specific quaestio, the quaestio which dealt with these kinds of crimes, was actually established. We just don't know. There is some speculation in the written version of my paper. You can find a footnote on this. These quaestiones perpetuae were jury courts, meaning that Archias's case was decided by a jury of Roman citizens. The proceedings were presided over by a certain type of Roman magistrate, the so-called praetor, which is a relatively high position in the Roman political career ladder. It should be noted that both the jury and the praetor had usually not received any legal training. Indeed, according to the Scholia Bobienza, it was actually Quintus Tullius Cicero, the brother of Cicero, who presided over Archias's case as praetor. Maybe just a little bit more on the jury itself. So like nowadays, Roman juries also had a variable composition. The juries were chosen by lot, just like nowadays, from a judge list of the quaestio concerned. However, parties did have the right to reject some of the potential members of the juries because they thought that they would not be objective. Again, this is something we still very much see today, especially in the United States, where the process is usually referred to as jury selection. The Roman juries were much bigger than modern juries. The number of jury members varied depending on the specific quaestio and the period of time we're talking about, but it might be as high as 75 jurors. So what about the prosecution then? Well, again, here we see a big difference with modern day criminal trials because Rome did not have a public prosecutor. Criminal procedures were, like civil law procedures, initiated by a private citizen by means of an accusation with the praetor presiding over the court in which you wanted to prosecute someone. This meant basically that anyone was allowed to bring a criminal prosecution in Rome. One did not have to have a concrete link to the case at hand. In the case of Archias, the prosecution was initiated by the otherwise unknown man, or an otherwise unknown man named Gratius. Why he brought this case against Archias is actually unclear. It is often argued that political motives were at play. But besides this, financial motives could also have prompted the prosecution. At least some criminal statutes promised considerable rewards for a victorious prosecutor. So there was money in prosecuting someone. However, we do not know if the law constituting this specific Quaestio also had such a clause, but it is quite possible. From the survival of Cicero's speech, we know that Archias had at least one lawyer pleading his case, namely Cicero. However, it was not uncommon to have more than one advocate take up your defense. And this has been already touched upon by both previous speakers. This is, of course, a sign of social standing, of showing that you have social connections. And of course, the presence of these influential friends could very much work in your favor during your case. Nevertheless, what's interesting is that Cicero does not refer to any other speakers in his speech, and this is quite uncommon for Cicero, and therefore this has prompted the suggestion that maybe in this particular case, he was the only lawyer speaking on Archias's behalf. Finally, some words on the audience. So these Quaestiones Perpetuae were probably located at the Forum Romanum, and therefore they took place in a very public setting. In other words, an audience must have been present. And Cicero also alludes to this fact several times in the exordium of his speech, when he addresses the audience explicitly and mentions that not only a crowd of many, but also of very cultivated persons has shown up to attend the trial. How did the trial proceed in this court? Well, in criminal cases, the proceedings were mostly shaped and conducted by the parties themselves. Again, here we see a difference with modern day criminal law, where it's usually the judge who is managing the whole, all of the proceedings. In Rome, the parties and their advocates were solely responsible for presenting their arguments and for the furnishing of evidence, such as the production and cross-examination of witnesses. The praetor usually did not take an active role in the proceedings, but restricted himself to ensuring the orderly conduct of the trial, while the jury just listened. After both parties had had sufficient opportunity to plead their case, usually this was measured with water clocks, the verdict was reached by means of a secret vote. Each jury would get, each jury member would get 2 tablets, one with an A for absolvo, one with a C for condemno, and of the 2, he would place one in an urn, thereby casting his vote and giving his judgments. After all the jury members had put their small tablet in the urn, the votes were counted, and whichever judgment got the majority determined the verdict. So basically a judgment by majority. If the defendant was found guilty, the punishment would be clear from the statute on which the prosecution and the proceedings were based. The sentence for false claims of citizenship is not completely clear. Again, we don't know enough about this law. However, it seems very likely that if Archias was found guilty, he would be expelled from Rome and deported to his hometown. So with that possible punishment hanging over his head, I think we should have a look at how Cicero is trying to prevent this. So in his speech, Cicero has to prove that Archias did in fact acquire Roman citizenship in a legitimate way, and therefore was not falsely claiming that he was a Roman citizen. The legal basis for this argument is formed by the so-called Lex Plautia Papiria, which was issued in 89 BCE on the initiative of Marcus Plautius Silvanus and Gaius Papirius Carbo. And Cicero cites the most important part of its content in paragraph 7 of his speech. And again, I've put that one on the slides, and I'm just reading from the slide now. He was granted a franchise by the terms of the law of Silvanus and Carbo, which enacts that all who have been admitted to citizenship in allied communities must have been resident in Italy at the time of the passing of the law and must have reported themselves to the praetor within 60 days. So in other words, Cicero had to prove three things. One, Archias was a citizen of a civitas foederata, an allied community which had been awarded Roman citizenship by the Lex Julia de Civitate in 19 BCE. Again, there is a lot to say about this relationship between the Lex Plautia and the Lex Julia de Civitate. I don't have time to discuss this in this paper, but I have included some very useful references to very wise people in my paper, the written version of my paper. So the first requirement, citizen of a civitas foederata. Second, he must have resided in Italy when the Lex Plautia Papiria was passed. And thirdly, he must have reported himself to the praetor within 60 days after the Lex Plautia Papiria went into force. In sections 8 and 9 of his speech, Cicero deals with these legal requirements relatively briefly. So he starts by stating that Archias was a citizen of the allied city of Heraclea. As you know, he mentions also that he was a citizen of other cities in Italy, but this one is the one he wanted to use. So he says that he is a citizen of Heraclea, and this would, of course, entitle him to claim citizenship on the basis of the Lex Papiria. Problematic in this regard is, of course, the fact that by the time of the trial, the archives of Heraclea had been destroyed by a fire. And this meant that there was no longer any official record of Archias' citizenship of said city. Therefore, Cicero, of course, solves this problem because he produces this influential politician and friend of Archias, Marcus Lucullus, and an abbacy of Heraclea as witnesses who can attest to Archias' enrollment at Heraclea, and, as he stresses, and we already discussed, whose testimony can and should surely be believed. And this is, of course, a very nice example of what I just mentioned of the advocate of one of the parties bringing forward the witnesses, so furnishing of evidence in the form of witnesses. Regarding the second and third requirements, there seems to have been no real dispute that Archias was a resident of Rome at the moment of the promulgation of the Lex Plautia Papiria. So Cicero himself stresses this point several times in the narratio of his speech, most importantly in paragraph 5, 6, and of course 7, where he says very clearly, cum hic domicilium Romae multos jam annus haberet. So he had been living in Rome for many years. The same also goes for the duty to report oneself to the praetor. It was clear from the city records, the tabulae, that Archias had reported himself to Quintus Caecilius Metellus Pius, who served as a praetor at the time and, also very important, had taken care of these records on this particular matter with extreme precision, according to Cicero. Therefore, it actually seemed that there could be no doubt that Archias had met all the requirements set by the Lex Plautia Papiria and had therefore acquired Roman citizenship. But there was one more problem to tackle, because the prosecution had presented one more argument suggesting that Archias had never actually become a Roman citizen. It had pointed out that his name, so Archias' name, was not included in the census lists for the two censuses which had taken place between the promulgation of the Lex Papiria and the trial of Archias. So that's the census of 86 and 85 BCE and the census of 70 BCE. It is not completely clear, actually, whether enrollment into the census list was a legal requirement for obtaining Roman citizenship or not. It's just something which is debated upon in literature. It could, perhaps it was only, perhaps it should only be seen as a declaratory act, which proved that one had become a Roman citizen, but was not necessary to actually acquire the citizenship. As I mentioned, both views have been defended in modern literature. Cicero, however, is extremely clear on this point, although we of course do not know if he is so clear for legal reasons or perhaps for rhetorical ones. Either way, he says, and I am now reading from the citation of the slide, but since the census roll is no proof of a man's civil status, and since the appearance of his name there but does indicate that when the census was taken, he lived as a citizen, and then he continues with an argument which is basically, therefore we shouldn't attach too much importance to these roles. Moreover, as Cicero argues, there was of course a very clear and obvious reason why Archias had not been enrolled in the lists in the two census lists available. In both years, he was away on state business with his friend and patron Lucius Lucullus, and could therefore not partake in the census taking place in Rome, which was quite logical. And very important, such love for and devotion to the res publica should, of course, never result in a later punishment in the Roman courts of law. That then brings me to my conclusion. I hope that by discussing both the iudicium publicum and the Quaestio legitima, mentioned by Cicero in his introduction, I have given you some hopefully helpful insights into the legal context and content of the speech, and by extension, a really short introduction to the wonderful legal world of Republican Rome. Again, I want to thank the team members of the Europa Ciceroniana project for the opportunity to speak at today's workshop. Well, as Alte Koskan emphasized several times today, law matters. And I think this holds especially true for Roman law. It is, in the end, the common legal heritage which unites us all. And I therefore hope that through you, Roman law will find its way to the classrooms all over Europe. Thank you.